closing arguments.
There is no conspiracy. There is no cover-up. There is no evidence of any of that.
Ladies and gentlemen, there was a cover-up in this case, plain and simple.
And rising tensions.
Make a hole, guys, make a hole.
The fate of Karen Reed now in the hands of the jury.
The defendant is guilty of each of the 3 indictments before this court.
You're the only thing standing between Karen Reed and the tyranny of injustice.
We are breaking it all down right now on Canton Confidential. The Karen Reed murder trial starts now.
We're on night 1 of Verdict Watch here on Canton Confidential. Thanks for being with us. I'm Glenn Jones.
I'm J.C. Monahan. Jurors deliberated for almost 3 hours before going home for the day. Now, today, jurors heard those closing arguments, first from the defense, then the prosecution. That was followed by instructions from the judge. Deliberations now continue tomorrow.
Our Kirsten Glavin live at Norfolk Superior Courthouse. Much quieter now than it was just a few hours ago. Kirsten, walk us through the big points from today, both inside and outside the court.
Yeah, Glenn, in terms of people here, this was hands down the biggest day of the trial so far. Now it's all eyes watching closely for a verdict.
Karen, how are you feeling leaving court today?
Right now, I don't know if nerves are the right word. Anticipation and. Excuse us.
It's a little overwhelming.
Yeah.
Emotions at an all-time high for Karen Reed and her defense team, leaving the entire murder trial in the hands of the jury. Outside of court, hundreds of supporters lining the streets around the courthouse, wearing pink and holding signs.
Not guilty verdicts coming back. I mean, the evidence showed it.
Also leaving members of the Albert family and Jennifer McCabe, who all testified but declined to comment.
Would you like to say anything about the closing arguments?
Inside, during closing arguments, Reed's defense summarizing an alleged conspiracy to frame Reed for John O'Keefe's death.
Conflicts of interest? Doesn't matter. Just look the other way. Magic hairs, magic glass. Look the other way. Late night calls and Google searches, falsified affidavits, inverted videos, and butt dials galore. Just look the other way.
The Commonwealth laying out a timeline of events from the drinks at the bar to voicemails left on O'Keefe's phone. Assistant District Attorney Adam Lally asking jurors to stick to the facts.
What the constellation of the facts and the evidence ineluctably demonstrate here is that the defendant drove her vehicle in reverse for 24.2 miles per hour for 62.5 feet, struck Mr. O'Keefe, causing those catastrophic head injuries, leaving him incapacitated and freezing to death.
Mr. Lally, I have to stop you. You've gone over.
Now, national and international media outlets are also out here waiting for a verdict to come down. That is on top of the hundreds of supporters that we've seen out here also standing by. JC, Glenn.
All right, Kirsten, we'll see you back at your post tomorrow. Thank you. Joining us in studio tonight is local attorney Morgietta Durissier. It's good to have you back.
Thanks for having me. Morgietta, we're going to talk about the defense. We're going to talk about the prosecution. We want to talk about what their final message was for the jury. The defense was up first, so we'll begin with them. Here's just a moment from court and attorney Ellen Jackson.
So how does a cover-up happen? How could that happen? Well, let's count the ways, shall we? Handpick your investigator. Make sure it's someone we know, someone on our side. Keep him close. Offer him help. Offer him a gift. Have secret friends and family meetings. Get your story straight. Delete your call history. Make mysterious phone calls at 2:22 a.m. Delete Google searches. Monitor police activity. Get rid of evidence. Get rid of your dog. Destroy your phones. Destroy your SIM card. For the investigator, decide on a narrative early on. Don't go to the crime scene. Don't take witnesses in for questioning. Question all the witnesses together. Ignore witnesses who don't fit your narrative. Allow friends and family to contact those same witnesses. Don't record interviews. Write vague and false police reports. Omit witnesses' names. Omit witnesses' interviews altogether. Don't photograph the evidence. Don't conduct any forensics. Don't document the evidence. Don't document the logs. Don't create any logs whatsoever, and don't maintain a chain of custody. Keep all the evidence in the hands of one person and then manipulate that evidence, including videos. Don't turn over videos. Invert videos. Turn 4:16 p.m. into 5:30 p.m. in affidavits. Turn 3 pieces of taillight into 5 pieces of taillight. Delete 42 minutes of surveillance footage, hide personal relationships, make this case cut and dry, and ensure the homeowner, quote, never sees any because he's a Boston cop. But most importantly, pick your patsy and pin it on the girl.
That's a snippet. Each side got an hour for their closing. Morgietta, which points do you think Alan Jackson was really able to hit home with that?
Well, let's just say in general, he definitely appealed to the jury, right? He was hitting home the heart of it, the crux of what he believed Karen Reed would have said herself, right? All the inconsistencies, what evidence wasn't presented. And that's what a defense attorney is supposed to do. Highlight all of the information that you did not see during this trial. And he did exactly that.
Yeah, it was a strong closing.
It was very strong. It was a very strong closing. And, you know, most of the time you don't use notes, but he needed that layout because he wanted to hit home those very specific points about what was not presented. And again, don't have to present anything, right? But he is pointing out what the prosecution's deficiencies were, and it was very strong. Yeah.
All right. Well, let's evaluate how the prosecution did. Let's talk about ADA Adam Lally, who gave his closing next. Let's listen to part of his message.
There's certain things that have come up over the course of this trial as far as evidence and testimony are concerned, little things. And what I would suggest to you, it's those little things that are quite telling as it pertains to the defendant's statements and the defendant's actions over the course of January 28th and January 29th and beyond. And I'm going to bring some of those to your attention as I go through, but just ask you to keep that in mind as far as when you're deliberating, when you're reviewing this testimony and this evidence. The little things matter. The little things start piling up in this case. Throughout the course of this trial, you've heard a lot of purported evidence or questions of witnesses in an attempt to distract you from the evidence in this case. It's essentially defense by obfuscation. It's a 3-card money trick. The facts and the evidence in this case are your card. They're the Queen of Hearts. And so what I want you, or what the defense wants you to do, is not look at that card. Look at anything else. Look at movement, look at this person, look at that person, look at text messages, look at this. Don't pay attention to the facts and the evidence, because if you do, what it will ineluctably lead you to is that the defendant is guilty of each of the 3 indictments before this court.
All right, Morgietta, so a different style there. Did he land with his arguments?
So here's the thing. Closing arguments are supposed to tell a story, right? You're supposed to appeal to the jury. You could definitely see they both were using paper, but ADA Lally was kind of reciting facts, right? As opposed to Alan Jackson, who was giving you that story, giving you that feel for what, you know, he was presenting and what was presenting during trial. So it was definitely different styles. One was more factual based, but you want that story to come out. You want that appeal to happen to the jury, definitely.
You know, one thing we talked about at the beginning of this trial was how much time the prosecution spent on the weather, on who was in the house, when they walked out, when they walked in. I didn't hear any of that really at closing. Is that typical? Because I'm trying to get an understanding of why so much time was devoted to that if upon closing we're not really even talking about it.
You know, a lot of this, you know, again, is based on strategy. We don't know why all that information was put in and not put in the closing. I think it was a missed point by ADA Lally because a lot of time was spent on it. And just looking in that particular clip, he pointed out what the defense didn't say or did say, and just should have really focused on what he presented, what strong evidence that he had, because the defense went in and just pointed out the inconsistency. So I think he missed that point a little bit.
Let's talk about one of the tools he used, which I think may have been effective. It's a timeline. It was shown in a graphic. It pointed out key moments of text messages and phone calls and events in the prosecution's theory of this case. It seems to be the cleanest communication we've seen on the timeline that was hard to follow from witnesses. What did you think about this tool?
So this is what we categorize as a chalk, right? And it's something that is also called a demonstrative evidence. And for the prosecution, they needed that because of the amount of witnesses that they had. I think this timeline actually clarified what they were getting at. But just remember, they still have to prove that she's guilty of that. And even having the timeline of the facts, they need to point towards more of what they're charging her with. And I still feel like even with this chart, it was a little bit missed.
So they came up short.
A little bit short, yeah.
Okay. Where'd you get it? Thank you. When we come back, we're breaking down the charges and talking about which one the jury may have the most trouble with.
A reminder, you can catch up on all of our Canton Confidential episodes on our website or YouTube, or you can listen to the show wherever you get your podcasts. Just search Canton Confidential.
Welcome back to Canton Confidential. Karen Read is facing 3 charges. The jury must now decide which, if any of those charges, she's guilty of.
Let's break them down. The first charge is murder in the second degree. Now, in order for Karen Read to be found guilty, the Commonwealth must prove beyond a reasonable doubt that Karen Read caused the death of John O'Keefe, that Read either intended to kill O'Keefe or intended to cause grievous bodily harm, or intended to act in a way a reasonable person would have known created a strong likelihood that death would result.
The second charge is manslaughter while operating a motor vehicle under the influence of liquor. The Commonwealth must prove Read operated a motor vehicle, did so on a public way or in a place where the public has a right of access, and Read was under the influence of intoxicating liquor. The Commonwealth must also prove that while operating a motor vehicle, Karen Read did so recklessly so that the lives or safety of the public might be endangered, and that her acts caused the death of another person.
And the third and final charge Read is facing is leaving the scene of personal injury and death. Again, the Commonwealth must prove Read was operating a motor vehicle, that it occurred on a public way, and that she knowingly collided with John O'Keefe. The Commonwealth must also prove that that collision resulted in death, that Karen Read failed to stop and failed to do so for the purpose of avoiding prosecution or apprehension. We're joined now once again by local attorney Borgietta Durissier and our courtroom insider, of course, Sue O'Connell. I want to ask if the prosecution has successfully hit all of those marks, but maybe we break it down. Let's just start with the first one of second-degree murder.
Right. So with second degree, and this is coming from a defense attorney, you have to prove intent, and I think that's going to be the hardest battle that they're going to have here, is proving that she intended to do that, and not only that, they have to prove each element of the second degree murder. So it can't just be one, the first one, A or B. It has to be all of them beyond a reasonable doubt. And I think they're going to have a hard time doing that, especially with the intent.
Well, on manslaughter, recklessness seems to be the standard. Have they proven that?
So the same thing, you have to look at, there are other elements that point towards like the intentional action of the reckless behavior, right? And so all of the counts pretty much have that element of intent, that they have to really show that Karen did so and knowingly did so and chose not to continue to follow the law. And it's going to be really tough.
All right. Well, what about operating a motor vehicle? You already said recklessly, but it's leaving the scene of personal injury and death. That's the least of the 3 charges. Right. Is that something that you could see the jury could come to a conclusion?
And I also think, again, there's a knowing element. One of the instructions in there has a knowing element. It can't just be one of them. It has to be all 3 of them. Absolutely.
All right. Well, you paint the picture where the prosecution has got a steep hill to climb here. I'm not sure if they're going to get to conviction based on the analysis you're giving us now. Sue, let's talk to you about this viewer question, because this viewer is asking about the length of time for the jury to deliberate. This viewer wants to know, Michelle, with the jury being excused for the day, do you think this means they can't come to an agreement?
No. I mean, they just got lunch. We talked about whether or not they could deliberate over lunch or just eat. Think about how hard we work on this show, right? And how much we have to learn every single time. We've been covering this case since jury selection. We've been covering it longer, but in this in-depth way.
Right.
And we rely on our experts, and we text each other. They are getting all this information for the first time, all of this evidence. They haven't had their notebooks. They don't have access to the internet. They don't have access to experts to ask questions of. So they have to sort through all this. And the jury instructions, right, which we also are trying to sort through. They have to go through that as well. So if they're being diligent, they're going to go through the evidence, go through the instructions, and then figure out. That's going to take at least a couple of days, I think, to be diligent to make sure they're following the law.
Just the jury instructions. Am I wrong in saying that was about an hour in and of itself? So it was an hour of closing arguments for defense, prosecution, then the third hour they're getting the instructions, and they were complicated.
Right, and just because they're boilerplate doesn't mean they're not complicated. Someone said to me next to me, oh, it's boilerplate. I said, okay, and then the detail of the law, like the judge has said since jury selection, I'll teach you the law in order to do this, and she is.
But she also said, you can't ask me any questions about anything except the law, because you can't ask me about evidence that was put in. You can't ask for transcripts. All they can go off of are their notes and the discussion that they're having in that room.
Absolutely. And that's why, as an attorney, it's really, really important to be clear, concise, and likable, unfortunately, right? Because the last word is not only what they hear, but how they hear it and how it's resonated with them. Because they're going to remember the facts as they remember it. And they can't ask questions about, well, was it a snowy night? Was it a rainy night? If I say it was a snowy night, it's a snowy night. If you say it's a rainy night, it was a rainy night. They can't ask questions about that.
There was, one more question from Rich. Do you want to let them know?
This one is from Morgietta. He wants to know, what are the odds of a hung jury? That's from Rich.
Oh, here we go.
It's a hard question to answer.
Let's do it like textbook, right?
Yeah.
In order to have a hung jury, you have to have that one person that's just not going to budge, and they either believe that Karen is guilty or not guilty, right? So it has to be unanimous vote. I don't know. I think by listening to how the jurors have been behaving over the last couple of weeks, I think they're all in a consensus, but I don't know what that consensus is yet.
Yep.
We're going to all know soon.
Yes.
Morgietta, Sue, thank you. When we come back, we'll take a closer look at some of the familiar faces who were unexpectedly back in court today.
Keep sending in your questions for one of our experts. Send us an email at canton.confidential@nbcuni.com, and we'll be right back.
We're back now with Sue O'Connell, our courtroom insider. Sue, there was a moment at home today where I'm watching the trial on my cell phone, as I often do. I had to lean close because there were faces I recognized from earlier in the trial. Can you confirm for us who was there in the gallery?
Yep, Colin Albert was there, Brian Albert was there, Jen McCabe was there, and Kerry Roberts was there. And they were sitting with the O'Keefe family behind them. You know, a show of solidarity. Remember, the jurors are looking right at the O'Keefes. They are right across from them and from the O'Keefe family and supporters. So definitely sending a message of solidarity. Look, my heart goes out to the O'Keefe family having to deal, obviously, with this tragedy. And I understand that people are supporting Karen Read and supporting justice, many of them for John O'Keefe as well. But going through this crowd of pink and cheering and, you know, just support for Karen, I can imagine that it must be painful to go and not see a lot of support. So I know they're witnesses. I know that they've been part of this, you know, this narrative, but at the same time, they were there to support the O'Keefe family.
I'm glad you clarified that, because we got a lot of questions on that today as well.
Yes, and also that Karen's family and friends are behind her.
Correct.
Because there was a viewer who wrote in and said, how come they haven't swapped out so that they're right and she can turn around and
she
talk
talks to them all the time, and it's even in sidebars. So it makes, I mean, it's a small courtroom. We're all right on top of each other, but, you know, they are close, and that makes sense.
Once again, the day started with more drama. Can you tell us we lost another juror?
Yes, of course. It was very somber and serious and heavy in there while we were waiting. None of the frivolity that's been happening in general with Karen and her supporters and family, all sitting waiting. And then the judge calls a sidebar, and we're like, here we go. And then we see the camera tilt up toward the fan. We saw the court officer go over and tell the camera operator to tilt it up so we wouldn't accidentally show a juror again. And we said, oh no, a juror's coming in. And one of our favorite jurors, just by looking at her, we have no information about her, one of our favorite jurors who has been really expressive. And when I've sometimes said, she's given a WTF face, that juror, she came in. She was dressed very professionally. I mean, they're always dressed well for the, you know, however their style is, but she looked like she was going to court. She came in, sidebar, judge went to her chambers, came back, and she was gone. And now we had those two empty seats. We had another one on the side, but right in the middle.
It leaves us with two alternates during jury deliberations.
Right, so we're still stacked.
Yes.
Just so we know.
And we have 6 men and 6 women, which now evens it out. What used to be a majority female jury.
Okay, Sue, thank you. We'll be right back. All right, let's get to some video that is just in. This is video of a town select board meeting happening right now in Canton. We're hearing from residents about their concern for the city and for the select board. This case, of course, has had ripple effects for many residents in that town. We're going to bring you much more on their reactions tonight at 11 when me and Priscilla Casper see you.
Fractured small town that hopefully we can find a way after this trial to heal for everybody there.
All right, we'd like to leave you with a reminder of the victim in all of this, John O'Keefe.
It's been almost 2.5 years since John tragically lost his life. He was killed January 29th, 2022. The 46-year-old served Massachusetts as a veteran of the Boston Police Department, a loving son, friend, and guardian for his niece and nephew, and now we await a verdict.
When it happens, we'll carry it live on air, on our app, and on our YouTube page.